Yes, Your Honor. I had a chance to speak with Ms. Davis from the prosecutor's office. She made the following offer: she will dismiss the charges against Mr. Schwartz, if he pleads to 2 counts of domestic violence. He will have 769-4A treatment for both of these counts, and the balance of the charges will be dismissed.
The prosecution would have no objection to 769-4A.
Correct.
Well, I do. I guess we can. Miss Akers, you can go have a seat on the bench there.
Thank you.
All right. Mr. Schwartz, you're charged with assault with intent to commit great bodily harm, assault with a dangerous weapon, and domestic violence. The prosecutor has agreed to dismiss the assault with intent to commit great bodily harm, turn it into a domestic assault. Assault with a dangerous weapon would be dismissed, and the second count of domestic violence would be a misdemeanor. So there would be a plea to 2 counts of domestic assault. Those are misdemeanors punishable by up to 93 days in jail and a fine of up to $500. Also, this goes without saying that they would not charge you with possession of a firearm during the commission of a felony, which carries a mandatory minimum 2-year prison sentence. Do you understand?
Sir.
Did you have a chance to consult with your attorney regarding that?
Sir.
And are you going to plead guilty to those 2 charges?
Yes, sir.
All right, let me ask you a couple questions. You sat through this testimony, same as the rest of us, but did anyone promise you anything other than this very generous plea agreement to get you to plead to this charge
Yes, sir.
or threaten you?
Yes, sir.
Do you understand that if you do plead to this charge, you will be giving up your right to have a trial? This preliminary examination was to determine whether there's probable cause to believe there's a crime. At a trial, you'd be entitled to be proven guilty beyond a reasonable doubt. You're giving that up. You understand?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Moore is here. You could also have had an attorney appointed if you had requested. If you had a trial, you'd have a right to take the witness stand yourself and testify and tell your side of the story. But you don't have to, because you have a right not to testify, and if you did not wish to testify, the judge or jury cannot hold your silence against you. And you could, I don't know if I said this already, you have a right to have any of the witnesses for or against you subpoenaed. And as I mentioned, you have the right to be proven guilty beyond a reasonable doubt if they're able to do that. To understand all that.
Yes, sir.
All right, we're asking about two separate incidents where you assaulted your girlfriend, children, mother. On this day, August 22nd, were you guys together at the Cranberry Lake address?
Sir.
And did you and she get into an argument?
Yes, sir.
All right, did you put your hands on her?
I pushed her, yes, once, and she's right. I did reach through the truck, at the window of the truck, and pull her hair once.
All right, so you pushed her, did she fall down?
No,
Where did that pushing take place?
mid driveway, right by the gate.
And then you pulled her hair and yanked on it when she was in the truck.
Yes, sir.
Which truck was she in?
She was in the little truck that I left in,
All right, which is what?
which is a 2004 GMC Canyon.
All right. And so that belongs to your father?
It belongs to me now. I bought that from the estate.
All right, but she was gonna leave in that truck and you didn't want her to?
She got in the truck because she was, because I was yelling and telling her to leave, get out of the driveway.
How long have you lived together there?
We've lived together there since 2018. My dad recently passed in 2021, day after Thanksgiving.
You and I discussed that. You don't have a clear understanding of landlord-tenant law. She's not a piece of luggage that you just throw out and say, leave. She's a lawful occupant and tenant of your house. You also don't have a very good understanding of child custody law. As the two of you are not married, she is presumed to have paramount custody of the children. So you're treating them like a pet, and you're treating her like a piece of furniture that you could put out of the house when it was time to, when you felt like it was time to. So I'll accept your plea. Ms. Davis, does this encompass anything to do with the allegations that he tampered with a pending witness or obstructed justice?
No, that was not part of it, and we haven't decided on anything because nothing has been sent up yet. So I haven't seen the evidence.
This encompasses only the actions of August 22nd.
Correct.
Is that your understanding, Mr. Moore?
Yes.
All right. All right, are you satisfied with the factual basis, Deborah?
It's sufficient. Thank you.
Are you, Mr. Moore?
Yes.
Now, what the prosecutor said, and your lawyer said, is there's a section under the domestic violence law which would allow you to be placed on a probation. And if you successfully completed the probation, the charge would be taken off your record. And I can only do that if the prosecutor consents. You've been in jail now for 19 days, and then you did some days at the front end. So let's see how long you were in jail.
20 days, Your Honor.
You got arrested on the 26th of October, and you posted bond on November 4th. So that's 5 days in October. No, the bond was posted on the 27th, so you just did 1 day. So you're right, you've done 20 days. I believe everything that Jenny Akers said to the trooper at the scene. I believe everything you said right then and there was the truth. And it most generally is what is said closest in time to the facts. And I regret the fact that I believe you just committed perjury here in open court. But I wasn't there. But I believe you. And I believe everything you said on August 22nd. I don't want to defer your sentence, and I don't want you on probation. I think you're manipulative and potentially dangerous. And you can all go home and look up gaslighting. He's telling you you're crazy and you need mental health treatment and you need to get your act together. Making all this somehow your fault. And then you hide from service, don't show up in court when you are actually served, and come here to court today and give what I believe to be false testimony, which puts the prosecutor in a very difficult position in attempting to prove this case beyond a reasonable doubt. So they took what they could get, which is 2 counts of 93 days in jail, credit 20. I don't want you on probation. I don't want this to be deferred. I want it to go on your record. So that's my sentence. I didn't give anybody opportunity for elocution, but it isn't going to change my mind. All right, now you'll get good time with that. 93 days minus good time. He has 20 days, so that's 73 days minus about another 30, meaning he has about another 40 days to do, unless I charge him with something else. All right, Mr. Schwartz, you can go with the court officer.
Thank you, Your Honor.
Don't leave yet.